Heirs Property Preservation. Imagine that a couple owned a home in the early 1900s. They had 2 kids. They passed away without a will and no one probated their estate. This means that legally the home never passed to anyone. Then each of the 2 kids has 3 kids. Then each of them has 3 kids. And no one has made a will or tried to go to court to establish ownership over the house. In just a few generations, there are as many as 26 legal owners of the house, even if only one person is actually living there. This is called heirs property, or sometimes family land. This creates problems. For example, you are not eligible for a reduced tax rate for living on land you own. You may have difficulty securing homeowners insurance and FEMA assistance in the event of a natural disaster. You would also have difficulty selling or mortgaging your land or being eligible for home repair programs. Let's talk about how to prevent an heirs property problem. First and foremost, consult with an attorney and get a last will and testament and an estate plan, a plan for what you want done with your property after you pass away. If you have a will, make sure that your family knows where the original is and make sure that they know that it must be filed with the probate court after you pass away. The probate court will only accept the original will, so it is super important to keep track of where that original is located and make sure that it's in a safe place. Second, if your loved one dies and they owned property, it's important to go to probate court and probate their estate within 10 years of their date of death. You must do this whether or not they had a will, though. If your loved one does not have a will, South Carolina law determines who inherits their estate. If that person is married with children, the spouse inherits 50% of the estate, and the biological or legally adopted children split the other 50% equally. When someone has more than a few children, the splitting of this 50% can quickly complicate things. So the bottom line is that you and your family need to do some estate planning and make a will. You might be able to get this done for free at SCLS or get a referral to an affordable lawyer. Let's talk about how to deal with an heirs property issue. In South Carolina, after 10 years after a person dies, you can no longer probate their estate. Instead, you must bring a formal, more complex and expensive court action called a petition to determine heirs. This court case requires a hearing, testimony, and certified documents proving who the descendants' heirs are. The cost of the certified documents can be expensive. These documents are things like birth certificates, death certificates, and marriage licenses. All of the heirs must be served notice of this action. You have to notify every heir, every person who could have inherited something, and the end result is that you get an order from the probate court stating who the heirs are. Unfortunately, a petition to determine heirs does not resolve the issue of who owns what. Instead, after the heirs are determined by the probate court, all the heirs must agree in writing about who gets ownership of the property. If the heirs can't agree, they can file another court case called a quiet title action, in which a judge determines who owns the property. These cases can be complicated, expensive, and go on for a year or more. This is why it's better, simpler, and less complicated to probate a loved one's estate right after death. Some common misconceptions about how heirs property works. 1. Because the original landowner told you that they were leaving the property to you, it's yours. This is false. Any type of transfer of land ownership must always be in writing. This is why it's important to have a will and to probate estates within 10 years of someone passing away. 2. If you pay the property taxes, you end up owning the property after a number of years. This is false. And 3. If you let the property get sold at a tax sale and you redeem it, you will own it outright. This is also false. The law doesn't allow you to cut out the owners this way. Untangling an heirs property situation can be technical and challenging. Please reach out to SCLS and see if we can help or refer you to a lawyer who can.